Hello, everybody.
We now move to agenda item 3E in the matter of Angelica Vasquez, cause number 0595. Ms. Smith?
Yes. On August 2nd, 2023, Gary Coleman, the complainant, filed a complaint against Angelica Vasquez, the respondent, alleging the respondent filed a false return of service and did not personally serve the complainant, but instead placed the citation in his mailbox. Due to the amount of time that has passed, the respondent was unable to recall details regarding this serve and admitted she may have delivered the documents to the wrong individual.
We did find violations in this case of 2B, Code of Ethics 2B, 2C, 2D, 14E. Per the sanction matrix, we're recommending a permanent revocation of the respondent's process server certification and a penalty of $2,000 total, due within 12 months after the date of the final order.
That's pretty much the exact same staff recommendation as we just had with Mr. AlLeGeDlY, right?
That's correct.
Comments or discussion? I see a trend here of going back to the old process. Any comments?
Do we have the respondent here?
I'm sorry, I forgot to ask. Do we have Ms. Vasquez here?
No.
Do we have Mr. Coleman here?
No, he was not going to attend.
Okay. And we also have the same defense. I guess due to the amount of time that has passed, the respondent was unable to recall details regarding the serve. The respondent admitted that she may have delivered the documents to the wrong individual, which is a necessary consequence of failing to maintain adequate documents to prove your serves. I'm in the same position that I was on the previous violation. Do we have a motion from the other side as to whether or not to accept or reject the staff recommendations?
Make a motion, we accept the staff recommendations.
Okay, I gotta ask, why do that with this one, but not do the same with AlLeGeDlY?
Person didn't show up.
That was going to be my response.
Because I think part of the preamble talks about whether the person is corrected the situation, made amends to do it, and give compelling arguments to why not. And so they didn't even respond here in this case to provide any of that. Just a letter saying, yeah, I might have served somebody wrong, and that was about it. And takes full responsibility in the letter they provided.
Okay. I can go with that. Any questions or comments?
Only comment would be that the person previously showed up.
Okay. Well, I move to accept the staff recommendation. Okay, move the staff recommendation to the permanent revocation of the respondent's process server certification and an administrative penalty of $2,000 total due within 12 months after the date of the final order for violation of rules Code of Ethics 2B, 2C, 2D, and 14E. Do I have a second?
Second.
All in favor say aye. Aye.
Aye.
Aye. Aye.
Aye.
All right, motion passes. At this point, we're going to go into closed session. Okay, so Process Server Complaint Review Committee of the Judicial Branch Certification Commission will go into closed session at this time pursuant to the Commission's Public Meetings Policy Sections 8A2 and 8F to confer with legal counsel on agenda item 3F. Members of the public will not have access to the closed session. The host will stop streaming at this time.
We'll go down to Ernesto Chidas.
Thank you. You need me to reel you or you got it? You're on the other side of me. Sorry about that, Your Honor.
All right, domestic third, scores an 8, was overridden to a higher degree offend. And FTA score, what does the state think is appropriate?
Your Honor, I do see the victim, Miss Hicks is here, so I would ask for you to turn to her at the appropriate time. Your Honor, based on the NPRA score and the facts of the case, the state's asking for $10,000 bail. We would ask for DAS supervision. We're asking for a no contact order per statute for 120 days, as well as condition. We'd also ask for a GPS device before release with a no firearms clause. That's based on, again, the underlying facts of this case, but more importantly, his risk assessment that was overridden due to the fact that the defendant does have a prior domestic battery second out of Reno Municipal Court. That was with the same victim that is alleged in this case. He's also got a domestic battery first out of Reno Municipal Court. Both of those convictions were in 2021. Although those convictions were from 2021, they've actually continued into 2024. He was put on a pretty lengthy probationary period. That first case does have a warrant outstanding. He was arrested on that when he was arrested on this case. It looks like he failed to appear at a review hearing post-sentence, and a bench warrant was issued for his arrest. That first domestic battery was with a different victim. In addition to that, he has convictions for receiving known stolen property, a misdemeanor out of California in 2014, and another misdemeanor conviction for domestic battery out of California in 2010. So based on the felony third offense, his risk assessment overridden to higher, as well as his continued criminal activity, the state believes that $10,000 with those conditions is appropriate. We did speak with the victim. I'm not sure if she wants to make a statement to the court or not. She was sort of unsure how she was feeling about a no contact order, or sort of where her relationship with the defendant lies right now. She did not believe that he had access to weapons, and she was unsure if he had mental health or drug or alcohol issues. But again, I'll ask you to turn to her at the appropriate time.
All right, thank you, Ms. Meyer.
Thank you so much. I think that we're going to be asking for an OR release. I think that that's supported by Valdez Jimenez, and I'll detail why. Ms. Casso did a great job of reciting the criminal history. I think that two things are evident in that. One is that the history that doesn't involve this instant case, because this is an enhancement, date back 10 and 14 years. There was then a period of law-abiding pro-social behavior, or at least not criminal offenses. Then in 2021, both offenses came pretty close together in time. I do have that failure to comply, but I had that as a failure to comply, not as a failure to appear, based on inability to meet the financial obligations of that first Reno Muni case. With regards to the second one, it appears to me, and I can stand to be corrected, that Mr. Enriquez completed his 52-week course, did his counseling, did the things that he needed to do. And I think most importantly, didn't reoffend during the period of oversight, didn't get new charges, and was able to comply and comport his behavior with oversight. Ms. Casso said appropriately that that was a relatively extended probation period, and he was able to complete that, which suggests to me, and I think the argument that is supported by that evidence, is that he can be overseen in the community. So if there are mental health and substance abuse concerns, we know that CARES campuses where he was, pursuant to the PC sheet, he can get the services there or coordinate with DAS to get access to them somewhere else. if that is the primary concern and what led to this offense, I think that is the better way to keep the community safe. And that there's not a clear and convincing argument with that 8 score to necessitate a bail hold, but there is with that 8 score in the moderate region, a need for oversight. So I would ask for DA supervision with enhanced pretrial services and recommend a substance abuse evaluation conducted within the first 30 days of release.
All right, thank you. Miss Jennifer Hicks, is there something you'd like to say? Just go ahead and unmute yourself. There you go.
No, Your Honor.
All right, thank you. Thank you for being here. So first, with regards to the score, the defendant was overridden to a higher degree offender failed to appear. When Dr. Austin validated the NPRA, he looked at the incidents where Washoe County Pretrial Services used their override, and he found that they appropriately used their override, meaning that people that they overrode from medium to high actually behaved as higher risk individuals. And so in this case, he is a higher risk individual. Higher risk individuals, again, according to the validation study that I have in front of me, are in the 50th percentile of being successful, showing up for all the court appearances and avoiding arrests during that pretrial release period. So they're certainly in a higher risk category. Then when we look at the least restrictive means analysis, we have an individual that is on an open domestic battery case when he's alleged to have committed another domestic battery case. I don't think we need statistics to tell us that that individual is a high risk to reoffend, that a court is supervising him for the exact same crime that he's alleged to have committed here, and that supervision has not been successful in keeping the community safe. He's done 52 weeks of treatment, I'm told, and that's not been successful in keeping the community safe. And so under least restrictive means analysis, I'm compelled to release him if there's conditions I can set that ensure the safety of the community and appearance of the defendant, but I have none. Everything's been tried, it appears, before. As far as the substance use disorder treatment, the administrative code requires everyone on a domestic violence treatment program to be screened for substance use disorder. So I have to assume the law was followed and that was done. So there's nothing I'm being offered that hasn't been tried before. Therefore, under the least restrictive means analysis, bail is necessary to ensure the safety of the community and the appearance of the defendant. He is a recidivist, a violent recidivist by nature of all of these criminal offenses for the same type of offense. So therefore, the bail will be set at $50,000, 50. There is no 10% option, no context, separate criminal defense pursuant to NRS 1784845 for the maximum 120 days. Ankle bracelet in place before release to ensure compliance, as well as residential confinement, no firearms. Checking with DA's order to obey all laws, make all court appearances. Next court appearance will be for the filing of the criminal complaint. I expect that to be on October 17th at 9 a.m. We'll see you back then, sir. Good luck to you.
Be safe, be well, sleep sweet, and much love.